Evidence presented in the Lucy Letby case shows that the Crown Prosecution Service have admitted that they got some of the evidence wrong. And I just want to understand the implications of that. So I thought I would get on a legal expert. We're joined by Joseph Kotrie-Monson, who is director of Mary Monson Solicitors on Fleet Street, which specialises in serious criminal cases, including child mortality cases. Thank you so much for joining us this evening. What is it exactly that has been got wrong in this case?
Okay, so the evidence relates to the child who about whom they couldn't come to a decision, and that was baby K, the attempt murder case that she was subsequently convicted in respect of on retrial, and it's to do with the logs of her attendance and crucially who was with her, because in the first trial, although there wasn't a conviction in respect of that particular baby, it was contended and accepted, I think, by the jury, by the prosecution. It was put forward by the prosecution that she was on her own at a particular time, and in fact there was what looks like, I suppose, have to give lawyers the benefit of the doubt. There's a greater risk of being found to have been misled, to have misled a court, which means most lawyers in these circumstances will not lie to the other side. But it appears that the prosecution, and I'm a defence lawyer, so I'm suspicious about these things generally, but it appears that the prosecution, Natasha in this case, got it wrong, and what they presented as a log of her being alone. And of course, she wouldn't necessarily have been in a position to correct that months later or even years later. In fact, there was another nurse present. Now, this is a single instance. It relates to one log. In a case of that kind of real complexity, multiple strands of not just evidence but incidents, perhaps it's not unusual to expect that mistakes would have been made. And crucially, the prosecution appeared to have brought that to the attention of the defence and the court before the jury heard the evidence on that subject in that subsequent trial, the attempted murder trial. So it appears that evidence didn't assist in the conviction in respect of the murders, because it related to the attempted murder. It's then volunteered in trial, in the later trial, and of course she was convicted despite the fact the jury were not misled knowingly or otherwise in trial too. So although it's in a case of this significance, public, it's grabbed the public's imagination. There appears to be a groundswell of people who weren't in the trial, who haven't read the evidence, who are somehow convinced that she didn't do this, much better than the jury who sat through all the evidence. But it doesn't appear that particular evidence has that much to do with the price of fish. And I don't mean to be flippant, and I'm defence-minded as a rule, but I'm also very wary of anyone who hasn't sat through a very, very long trial, heard all the nuance and said, well, this is our decision. I'm not going to place myself in that position, however defence-minded I would be.
That's a really good point that you make, and that does often happen with these high-profile cases, that you get these kind of amateur sleuths and amateur lawyers and amateur detectives who all have their own theory about what went on, despite not having access to the bulk of the evidence. And I'm reassured by what you say about it being a bit of a nothing burger in this particular instance. Joseph Kotrie-Monson, thank you so much, Director of Mary Monson Solicitors on Fleet Street, which specialises in serious criminal cases, including child mortality cases.